I'm Jeff Pokorak. I'm from Suffolk University Law School, and I'm here to talk about legal professionalism as opposed to law professorism. And what we are trying to do with our students is to have an outcome where we create new lawyers who relate not only to substantive knowledge, but also to a professional identity. There is a well-known distinction between the two, whereas law professors or legal professionals see themselves as professionals, and they think of law professors as kind of odd hippies. And there is also a divide when you think about the law professor side of it, where they see themselves as like great brainiacs with massive powers, and law professionals sort of as these disembodied heads who are looking in from outside, maybe with malevolent intent about changing the programming. So what we need to do is find that space between. Where can we find the space between the two cultures, between theory and practice, skills and ideas? And so I'm not addressing here sort of clinical professors or skills professors. I'm really talking about one cohort, which is doctrinal professors in the first year particularly. If you look at the studies, this is an area where professionalism gets hurt. There are different pole stars for these two communities. Lawyers must serve others. That's their job. They must be public-minded, and they have constraints on their behavior as well as ethical rules. Law professors value, perhaps more than anything else, academic freedom, personal liberty, few constraints on behavior, and students are thought of as being most responsible for the learning. Luckily, when I was kind of contemplating this, and I'm starting to study this and do some research in this area, I ran into one of the, I have to say, two most wise people in the known galaxy, Roberto Carrata. Sarek wasn't available. And he started asking questions about, like, what are the norms of the legal teaching profession? What are the professor norms that maybe should be translated from that profession into the legal profession? Is there a space or a way that we can sort of combine or think about the norms? So there needs to be a study, first of all, I guess, about the norming of law professors. There is room for this study, and I just did a quick study, which is going to be right here, of what, these are the 8 schools in Massachusetts. What are the number of professors, what are the number of law professionals as professors, with titles of professor. You'll see that, you know, it kind of goes up and down, and this is just by like number of professors. This is actually the look at the percentage at each school of law professionals as professors. The interesting thing is the leadership question. Only Harvard and Suffolk have law professionals as deans of the 8 schools. That would not have happened 20 years ago. It would not have happened. This is like the same percentages, but as a relationship to US News and World Report. There's a lot of questions in all of these graphs. Like, what does this mean? There's some distinctions. Maybe Northeastern and Boston are not rated the same way, but they have very different sort of goals for their students. So I think there's a lot of thinking about what might happen here. Now, this is also about the way that first-year professors think about their teaching. Some of them think about it transmitting through a mind meld all of their knowledge to the student. I think that they feel that this is the way that teaching ought to be. Of course, students sometimes feel this as being choked, that their ideas of morality and their sense of like what it means to be a communitarian are really undermined by the shadow pedagogy of the first year. I think that we should reconceive this all really as a teaching across 2 different species, where you're trying to communicate between 2 concepts or 2 cultures, namely professionalism of the legal profession and also the idea of the professoriate and that profession. We need, in that way, I think, to consider a blended professionalism model, which we do not currently have. There are a number of professional schools that are accredited independently from DOE accreditation that are moving in this direction. Engineering, sciences, even business schools and AACSB think of like very clearly about how many professionals should there be, how many scholars should there be, and actually require some version of ratios. So my hypothesis is like law faculties must be trained in professional norms. We can't talk about all this programming without having the actual teachers of this not undermining professional norms through their teaching, particularly in the first year. I have 3 takeaways. 1, why am I using 50-year-old cultural references? I mean, this is like the biggest mistake you can make, right? I mean, Don't do this with your students. Most of our students were born in the Bill Clinton administration. The second takeaway, though, is we use cultural references because they're amazingly sticky. So if you have a shared culture, then the learning is amazingly sticky. And so that's why they're very valuable if you're using the right cultural references. Lemonade, not Star Trek. And to do this, though, we have to have shared culture. And so the third takeaway is we need to basically work on not undermining professionalism, either through the methodology we teach, how we appear in front of our students, what we talk about we value in our own professional lives as a professor. We need to create and maintain teaching that teaches not only professional identity, but shared culture as well. And if we can do that, we can create a product that is a better product, and we can ultimately ensure that colleagues both teach and identify with the profession, and then we can all live long and prosper.